Hey y'all, it's Kosta. I help people break the system to build a better future. Today, we're talking about Medicaid estate recovery. All right, so what is Medicaid estate recovery? What do I need to worry about? And more importantly, how does it work? Basically, when a Medicaid beneficiary dies, the value of their estate, if they have one, is used to pay back debts before transferring to any heirs. The estate includes any assets such as a home, savings, or retirement accounts that are solely in the name of the beneficiary. Depending on your state's rules, jointly owned property, living trusts, and other assets can also be subject to estate recovery. This is why it's so important for Medicaid planning. Understand what your options are and understand how you can protect your estate and assets from recovery. If an individual has no assets at the time of death, there is nothing else that the state can do. The state can't ask the beneficiary's living heirs for repayment if there is no estate. If the beneficiary has a living spouse, a certain amount of their combined resources is protected so they are able to continue living independently. This is called the Spousal Impoverishment provision. In 2021, it protects assets worth up to $130,380. So who does estate recovery affect? Medicaid estate recovery applies to anyone who is age 55 or older when receiving Medicaid benefits, and individuals of any age who are permanently institutionalized. States can also pursue estate recovery for other Medicaid services for these individuals, except for payments of Medicare premiums. One way to think about estate recovery is that Medicaid loans beneficiaries financial support for long-term services and supports. And once the person becomes permanently institutionalized or passes away, the interest-free loan becomes due back to the state. Can Medicaid take away someone's home? Big question, right? Part of the estate recovery process looks at property owned by the Medicaid beneficiary and recovering some of that debt through the value of that property. This is called putting a lien on the house. The state can file a lien when the Medicaid recipient is institutionalized and not expected to return home. But how do we know that for sure? Or after the beneficiary's death. However, the state cannot seize or place a lien on a home if any of the following of the beneficiary's family resides there: a living spouse, a child under the age of 21, a blind or disabled child of any age, or a sibling with equity interest in the home who's lived there for at least 1 year prior to the beneficiary entering a nursing home. So where can you get help with estate recovery? The rules about Medicaid estate recovery are complicated and vary by state, like most Medicaid rules. My best advice is to consult an elder law attorney, estate planner, or Medicaid planning lawyer, preferably before utilizing Medicaid services. It's important to understand what you will be provided through state funding in life and what you and your family will owe in death. If you have any questions, please leave them in the comments section below. I'd be happy to help.